Well, congratulations. You finished the section of our course on torts, negligent torts, intentional torts, our background about the court system and the sources of law. For the rest of the term, we are going to focus on studying contracts. Chapter 9 is basically an overview of the law of contracts, some terms you'll need to know, and some exceptions to the requirements that every part of a contract must be there. Then the following chapters will get into more detail about some of the specific parts of contracts that we're going to talk just generally about today. What is a contract? One of the interesting questions that we're going to talk about is what makes a contract different from a promise? People make promises to us and break promises all of the time, but when they break a promise, there's nothing much we can do about it, from a legal standpoint at least. But when somebody makes a promise that has the status of a contract, if it's broken, the person who's harmed from the breach of the contract can go to court and get remedies. So we are going to take a look at what makes a promise a contract. And the very important difference is that a person who is injured by a breaking of a contract, which we're going to call a breach, breaking is a breach of contract, is entitled to call on the government to force the breaching party to honor the contract. So recognizing contractual rights in essence allows parties to create their own private law. We've seen how the government creates laws, but now two parties or three parties or more can get together, enter into a contract, and that becomes enforceable law as between those parties, with the power of the court standing behind it. What are the basic elements of an enforceable contract? And some of these elements are what is going to make a contract different from an unenforceable promise. The basic elements of a contract are, number one, an agreement that is made by both an offer and an acceptance. And in the next two chapters, we'll study what makes a valid offer and what makes a binding acceptance. But that's only one element of a contract. Number two, the contract must be entered into by the parties voluntarily. Number three, the contract must be supported by what we call consideration. And again, that's something we'll study a little bit later on. Number four, the parties to the contract have to have the capacity to contract. There are certain people who the law finds do not have the capacity to enter into a contract by themselves. One of those categories is someone who is a minor. The law says until you are an adult, you do not have the power to enter into a contract. And this, of course, is to protect younger people from being bound to something that they're not sophisticated enough to know about. So we say until you're an adult, you don't have the capacity to enter into a contract. And finally, number five, the fifth element of a contract is that the contract must be made for a lawful purpose. There are certain contracts out there that are illegal. Gambling contracts, or at least before gambling was legalized, used to be deemed illegal. A contract to commit a crime is an illegal contract. And that means that you do not have a valid contract. So those are the basic elements. And as I say, as the course goes on, we'll take a closer look at what these elements are, what they mean, what constitutes all of these valid elements. Now, there are a bunch of terms. This is a little bit boring part of the course, I have to say, because there are just a bunch of terms that you need to know what they mean, because we're going to run into them later on as we're talking about different areas of the law and as we're reading some of the cases. So we're just going to talk about some of these terms, what they mean, and what distinguishes them from the other types of contracts. So the first basic contract type is a unilateral contract. A unilateral contract is where only one party makes a promise. I promise to do something, and the other side doesn't agree. Rather, the other side goes out and performs the requested act. And when the requested act is completed, that is when the contract is formed. So an example of that is when I lose my dog Fluffy, and I put up a poster that says, if you find Fluffy and return her to me, I'll pay you a $1,000 reward. Now, you don't first come to me and say, I saw your offer on that signpost. I will accept that. And if I go out and find Fluffy, you'll pay me $1,000. No, we don't need you to do that because this is a unilateral contract. The way that a binding contract is formed under that circumstance is by you going out, finding Fluffy, and returning her to me. And when you do that, the act of returning Fluffy is what makes the binding contract complete. So one party promises, the other party performs. And the contract is not formed until performance is complete. In contrast to a unilateral contract is a bilateral contract. With a bilateral contract, both parties at the beginning simply exchange promises, no performance, an exchange of promises, and the contract is formed as soon as the promises are exchanged. This is the most common form of contract. There are far more bilateral contracts than there are unilateral contracts. So with a bilateral contract, an exchange of promises for action that's going to occur later on, binding contract is made as soon as those promises are exchanged. Our next term is an unenforceable contract. An unenforceable contract is one that meets the basic legal requirements for a contract to exist, but is not enforceable because of some other legal rule that comes into play. So we have a valid contract that would be enforceable except some other legal rule says it's not. So an example of this is there's something in the law called a statute of frauds, and we are going to study this later on in another chapter. It requires that certain contracts must be in writing. The general rule is a contract, an enforceable contract, can be either oral or written. They both have equal force under the law. The practical advantage of having a written contract is that you've got evidence, proof of what the parties actually agreed to. Right? But if you make an oral contract you don't put in writing, that's just as enforceable, except for some types of contracts. For example, a contract to convey real property, land or the buildings on it, must be in writing. An oral contract to sell land is not an enforceable contract. Right? So even though with your oral contract to sell land, you may have satisfied all of the elements we just talked about, an offer, acceptance, made voluntarily, supported by consideration for a lawful purpose, you have capacity to contract, but because of this other rule of law, that type of contract must be in writing, you have an unenforceable contract. The next category of contract is a contract that is voidable. Voidable is a contract in which the party that is harmed has a right to cancel their obligations under the contract. However, if the harmed party decides not to cancel, the party who is not harmed is bound to go forward with their obligations under the contract. We see voidable contracts when we talk about things like fraud and duress. Somebody was defrauded into entering into a contract, or someone entered into a contract only under duress, someone was holding a gun to their head, whatever it might be. The person who entered into the contract, acting under fraud or acting under duress, has the option to either go forward with the contract or to cancel it. The other party who committed the fraud or committed the duress is bound by the contract if the harmed party chooses to go forward. So that's why these types of contract are called voidable. It is void at the option of one of the parties. In contrast to a voidable contract, our next definition is what is a void contract. And a void contract is one in which no legal obligations are created on either side. No contract ever comes into being. And this, for example, may be a contract that's illegal. I hire you to go commit a crime. I want you to go break my ex-boyfriend's kneecaps. Something like that. Right? We meet all the other elements of a contract, but because it's illegal, it is not a valid contract. Neither one of us has any obligations under those contracts. It never comes into being. So that is a void contract. The next definition we're going to talk about is an express contract. With an express contract, the parties have directly stated the terms of their contract, either orally or in writing. It can be either one. But I either have with my words spoken clearly set out the terms of our contract or by what is written. It's evidenced by the words, whether they be oral or written words. In contrast is an implied contract. With the implied contract, there is not an exchange of words, written or oral, creating the contract. Instead, the agreement of the party is evidenced by their conduct, not their words. So, one of my favorite examples of an implied contract is when you go into a restaurant to buy dinner. You sit down, you look at the menu, you call the server over, you say, I would like to have the ribeye steak, baked potatoes, and your finest bottle of wine. The server takes your order, goes away, comes out, delivers the wine. A little bit later, comes out, deliver your food. You drink the wine, you eat the food, and you get up and leave. And the server comes over to you and says, wait a minute, you can't dine and ditch. You can't leave without paying for your food and your drink. And I say, what do you mean? We never had an agreement that I would pay you if you brought me that food or if you brought me that wine. You didn't come over and say, if I do that for you, your charge will be $85. Do you agree? And I shake your hand and say, yes, I agree. We didn't do that. We didn't enter into a contract. Therefore, I have every right to leave this fine establishment without paying for my food and drink. Right? No, the law won't let you get away with that. And the law, in that case, this is a classic example of an implied contract. We evidence by our behavior. When I came in, I sat down in the restaurant. I ordered off the menu. The server brought me the food. Our conduct demonstrates that I, in exchange for getting that food, will pay for what I got. So that is an implied contract created by conduct, not words. Finally, two last terms. An executed contract. An executed contract is when all of the parties have fully performed their contractual duties. The contract's over. Side A is performed, side B is performed, there's nothing left to do. That contract has been executed. In contrast to an executed contract is an executory contract. And that is a contract that has not yet been fully performed. Maybe one side has performed, but the other side hasn't. Maybe one side has performed, but the other side hasn't completely performed. Maybe neither of the parties has started their performance. And that would be an executory contract. Now, There are two sources of law that govern the interpretation and enforcement of contracts, and we have to be concerned by both. As we studied earlier, every state has its own set of laws, and contracts are a creature of state law. There's no federal law on contracts, with some exceptions, but for the most part, contracts, what creates a contract, how they're interpreted, how they're enforced, is all subject to state law. So we conceivably can have 50 different states with 50 different rules and laws about how contracts are formed, how they're to be interpreted, what damages are available if they're breached. And because of the existence of all of these differing laws, it became a problem when commerce started expanding across state lines. We're moving from the days where business was pretty much local, but now the economy has grown, forms of transportation has grown, the internet has grown. And now we start selling things across state lines, maybe into another state, maybe into another 10 states, or maybe in every state, and maybe internationally. Now, when you start doing business, say in all 50 states, if your contract is subject to different interpretation and different laws in all 50 states, it can create a big problem. So as a result of this, as commerce grew, it became more interstate rather than just within one state. The legal scholars, judges, lawyers decided that it would be important for commerce if we could come up with a uniform law that governed these contracts in every state, and then try to encourage all of the states to pass that same law. So that when you're selling goods in Wyoming, you have the comfort of knowing the laws in Wyoming are the same as they are in California. And that same is true of all these other states. So this effort moved forward, and the parties that were in charge of this, as I said, judges, lawyers, drafted what was called the Uniform Commercial Code. The Uniform Commercial Code that was a uniform law applying to certain types of contracts. We'll talk about what it applies to and what it doesn't. And then they encouraged all of the states within their state legislatures to pass that law as their state law. And it was very successful. Every state has some form of the Uniform Commercial Code incorporated into its state law system. One state, Louisiana, adopted half of it, not the whole thing, and a few states have tinkered with it here and there. But for the most part, the people who came up with this idea accomplished what they set out to do, which is to have uniformity across state to state in these certain types of business transactions where the UCC will apply to the transaction. We are going to study in this class only Article 2 of the Uniform Commercial Code. Article 2 governs the sale of goods. If you sell goods, we'll talk about what goods mean, then you are subject to this uniform law. What is a sale of goods? Goods are defined as tangible, movable, personal property. Personal property that you can feel, that you can move, but it does not apply to real property, right? Only personal property. It does not apply to services, and it does not apply to things we call intangible property. Intangible property. Intangible property are things like intellectual property rights. You have a little certificate evidence in them, but the rights themselves you can't feel. You own them, but you can't feel them. The same is true of your ownership in a corporation. You get a stock certificate that evidences that you are the owner, but that is not your ownership interest. It's just evidence of it. You can't feel your ownership of a business. So, if you are engaged in the sale of goods, you are subject to the Uniform Commercial Code. Your contracts are subject to the Uniform Commercial Code. However, if you are selling services, intangible property, or real estate, it is not governed by Article 2 of the Uniform Commercial Code, and those types of contracts go back to being governed by the common law of the various states. That can vary state to state. And if you remember, we defined common law earlier on in the course as law that is made by judges, as they are interpreting statutes, as they're trying to fill in the holes where the legislatures may not have provided all of the law. So, two different sources of law we're going to be studying. But remember, UCC applies only to the sale of goods. Common law applies to services, intangible property, and real estate. Now, some contracts involve both goods and services. For example, if I agree to paint your house, I'm selling you both paint, which is a good, it's tangible, movable, personal property, but I'm also selling you my services. So now if there's a dispute over this painting contract, the courts have to decide whether they're going to apply the UCC to interpret the contract and enforce the contract, or whether they're going to look to common law. And the two could contrast, and we'll see lots of areas where they contrast. So what does the court do in that situation where they have what's called a hybrid contract? A hybrid contract defined as involving both goods and services. And the tests that the courts will use to decide what law to apply usually turns on which element, goods or services, predominates in the contract. So in the painting example, someone who's hired to paint a house, most likely what predominates in that contract is services. The hours needed to be painting the house probably going to predominate the cost of the paint that's being sold to you. So in most instances, a contract like that would likely be governed by common law. On the other hand, say I buy a whole bunch of very expensive sound equipment for it to be installed all throughout my house, speakers and high quality music equipment, and I purchase that equipment from you, and I also hire you to come install it. Now in that circumstance, it's likely that the cost of the equipment is going to predominate, because we're talking about much more equipment and much more expensive equipment than the cost of the contract that's going to be devoted to you coming in and installing the equipment for me. So that is a case where likely, depending on the circumstances, the Uniform Commercial Code would be applied to govern that contract. Now, what's the basic difference between common law, judge-made law, and the Uniform Commercial Code when it comes to interpreting contracts? One of the things that the UCC attempted to do was, if they found that the parties intended to make a contract, both parties wanted to enter into a contract and maybe thought they'd made one, but because of some technical thing wasn't complied with, under the common law, there's no enforceable contract. One of the things the UCC tries to do is, when the parties did in fact intend to make a contract, but for some technical reason did not, the UCC will find there to be an enforceable contract. The UCC looks more to the intent of the parties rather than relying on the technical rules we're going to find in the common law. So one of the practical consequences of this is that it is more likely that a court applying the Uniform Commercial Code will find there to be binding contracts. More likely to find that the parties did have a contract between them rather than a court who is applying the technicalities of the common law. The UCC also wanted to impose higher standards in the marketplace. So in a contract governed by the UCC, the parties are required to act in good faith in performing and enforcing their contracts. Now, California common law actually has a similar requirement. It expects the parties to a contract to act in good faith, but not all states do. Not all states have laws similar to California. So one of the things the Uniform Commercial Code tried to do was to say, at least in the commercial context, in the marketplace, we're going to require that the parties act in good faith when they're performing their contracts. And finally, the UCC differentiates between merchants and non-merchants who sell goods. You won't find the distinction too often in common law, but the UCC does. A merchant is someone who regularly deals in the kind of goods being sold. So when I go buy a car from a car dealership, that dealership is a merchant because that's what it does. It regularly deals in the sales of cars. But if I go buy your used car from you, you're not a merchant. That's not your job. That's not what your business is. You're just selling one of your cars to me. So the UCC will distinguish between you and the car dealership. The UCC will hold that car dealership to a higher standard with respect to the sale of the cars than it will you. So again, we're trying to evidence holding people who are involved in commercial marketplace. We hold them to a higher standard under the UCC than they're usually held to under the common law. Now, sometimes, even though the parties haven't entered into a binding contract, the courts will make an exception and nevertheless impose a duty on a person as if a contract had been formed. And these are exceptions. The court says, nope, I'm applying the rules of contract. I see that you did not enter into a legally binding contract. However, given the circumstances, I'm going to hold you to a requirement as if you had entered into a binding contract. The two non-contract obligations that we're going to study are something called a quasi-contract and something called promissory estoppel. Let's take a look at quasi-contract and what that means. A quasi-contract is when one party confers a benefit on another who knowingly accepts it and retains it under circumstances that would make it unjust not to pay for it. What does that mean? One party confers a benefit on another who knowingly accepts it and retains it under circumstances that would make it unjust not to pay for it. All right, let me give you this example. Someone who lives on Sunset Road, let's say 110 Sunset Road, contracts to have their house painted. And the owner of the company comes out to meet with the person who lives there and to give them an estimate, and they decide to go forward. And the person who writes up the contract, there's a typo. And in the contract, the address of the residence to be painted is not 110 Sunset Road, but it's 110 Sunset Drive. And the painters take the contract, and now it's not the owner of the company, it's the workers are actually going to go out and paint the house. And they show up at 110 Sunset Drive. And it just so happens that Professor Fluggy lives at 110 Sunset Drive. And I'm getting ready, back in the days when I actually used to leave my house to go to work, but let's pretend I still do that. Getting ready to leave my house to go teach at CSUN, just like the good old days. And I note out my front window as I'm getting ready that these three people in a painter's truck have shown up. And they're starting to take out ladders and tarps right in front of my house. So I see that. And I finish getting ready, and I see now that they've even got some ladders up against the house, and they're starting to scrape some of my rickety old paint off my house, which is good because it really needed it. So I leave. I walk out the front door. I wave to the guys. I said, "Hey guys, how you doing? Nice day, huh?" They wave back. They say, "Yeah, great day. It's going to be nice and cool day to be painting." All right. I go to CISA and I teach my classes. I come back home, and lo and behold, those guys were great. They've got the entire house scraped. Looks like they're prepping. Looks like they're prepping to get ready to paint it. And the guys are still there. They're packing up their truck. I said, "Hey, nice job, guys. That looks great." Go back in, have my dinner, go to bed. Next day, same thing happens. Getting ready to go to work. These painters show up. They start applying some primer. I go to work. I come back. I see they've got the house all primed. Same thing happens. I greet the guys. I go back in. I have dinner. I go to sleep. Next morning, there they are again. And now they're painting my house. And they do a beautiful job. It looks fantastic. They finish their work. I get a bill in the mail. I ignore it. I get some demand letters. I ignore it. Finally, one day, the owner of the company comes out, knocks on my door, and says he's there to collect for painting my house. And I say, "What are you talking about? I never agreed to pay you for painting my house. Show me the contract." He pulls out the contract, and I see, well, that's not me. That's not me. See, that person, Jane Smith, my name is Professor Flugie. I'll show you my ID. Okay? Never entered into contract with you. Okay. The owner of the painting company takes me to court and says, "Yeah, she didn't sign a contract with us to paint her house, but she sat there day after day seeing all the work we were doing and never told us we had the wrong house, never told us she hadn't entered into a contract with us. And it wouldn't be fair under these circumstances for Professor Flugie to have this beautifully brand new painted house and not have to pay for it." And the court in that case is likely to agree with the painting company. So let's go back and think about that in light of the definition. When one party, that would be the painting company, confers a benefit on another, the benefit would be a beautifully painted house, who knowingly accepts it and retains it. Right? Day after day, I let them keep working. I knew it was happening. Right? And of course, I would get to retain it because they can't take the paint back. And would it make it unjust under those circumstances not to pay for it? The court is likely to say yes. Now, let's change the facts around. And let's say this all happened when I was on vacation in Hawaii. Never saw it happening, right? Never waved to the guys, never knew what was going on. I come back from my vacation, I pull into my driveway and I say, "Wow, I must have been out in the sun too long in Hawaii because it looks like my house has been entirely painted, but that can't possibly be the case." Now, I get demand letters, the owner of the painting company comes to me to collect, and in that case, it's likely that the court would not find there to be a quasi-contract between us. And that is because I did not knowingly and accept and retain the benefits. It may be unfair to the painter's company, but it wouldn't be fair to force me to pay something that I didn't have the ability to stop. So there's the difference between the existence of a quasi-contract and the non-existence of one. All right, so also illustrating this concept of quasi-contract is the case that I assigned for briefing of Simons versus Heaton. This is the case of a pathetic man named Placzek, who was a proud practicing alcoholic all of his life. And he clearly had been enabled by his mother. His mother had taken care of him his whole life as he practices alcoholism. And he's got a friend, had been a friend for a long, long time, who was a recovering alcoholic. And Placzek's mother, the alcoholic's mother, was getting on in years, and she was worried that when she died, there wouldn't be anyone to look after Placzek. So she went to Simon's, the recovering alcoholic and friend, and she said, when I can't take care of him anymore, when I die, would you please look after him? Would you please take care of him? And Simon's agreed. And after Plachek's mother died, Simon's moved into Plachek's home. He lived there for 9 years and did not pay any rent. So he was living there rent-free. He continued to work at his job, but he also did care for Plachek. He also did care for him. He did shopping for him. He tended to his needs. Plachek dies. And Simon's, I'm guessing, reading between the lines here, is aghast to find that either Plachek did not make a will, or if he did, Simon's was not in it. After all, he did for his friend for 9 years. So Simon's files a claim in the probate court, claiming that he had been entitled to pay almost $260,000 as compensation for the care and services he provided to Plachek. And he said, no, we didn't enter into a contract that if I took care of him, he would pay me. I don't have an enforceable contract, but I do have a quasi-contract because I conferred a benefit on Plachek and he knowingly accepted and retains it. And it would be unjust now if he didn't pay me for the services I gave him. Now, on its face, you could argue it kind of does fit within the definition of quasi-contract, right? He conferred a benefit, Plachek knowingly accepted and retained it, but the court got caught up on the last clause of the definition. Retains it under circumstances that it would make unjust not to pay for it. And the court took a look at all the circumstances and said, you know, there's nothing in your conduct that supports the conclusion that while you were providing these services, you had an expectation that you would be paid. You were doing this as a friend. You did it on a voluntary basis. This is not the type of circumstances where people would expect compensation. And you got to live there rent-free for 9 years. So the court, under these circumstances, found it's not a situation where it would be unjust for Simon's not to be paid. So in that case, the court found that no quasi-contract existed. The second non-contract obligation we're going to talk about is something called promissory estoppel. Now, here's a case where, generally speaking, promises do not rise to the level of enforceable contracts. Right? Somebody breaks a promise, it hurts you, but there's not much you can do about it. There are certain circumstances where a court will enforce a promise, even though a legally binding contract has not been entered into. Promissory estoppel is invoked when one party relies upon another party's promise to his or her detriment. That's generally where there's a difference between a promise that is enforceable and one that is not. It's whether or not you have relied on that promise to your demonstrable detriment. There are 3 elements necessary in order to impose promissory estoppel on a party. The elements of promissory estoppel are, number 1, a promise that the promisor should foresee is likely to induce the other party to rely on it. The party knows when they're making the promise, the other party is going to act on it. Number 2, the other party does act on it, does rely on the promise. And number 3, an injustice resulting from the reliance. Okay? So the promisor makes a promise knowing it is likely that the other side is going to rely on it. They do rely on it and act in a certain way. And 3, there would be an injustice resulting from that reliance if the court did not now enforce the promise that was made to induce this act. Problem case 3 that was assigned in connection with this lecture illustrates this concept of the application of promissory estoppel. And this was a case of Aceves, I think that's how the name is pronounced, it could be something else, Aceves versus U.S. Bank. Aceves had a mortgage on her home through U.S. Bank. And during the recession of 2008, she fell behind on her mortgage payments, and the bank was attempting to foreclose on her home. And like a lot of homeowners did during this time when they fell behind on their mortgage and the banks wouldn't work it out with them, they filed for bankruptcy protection. Because the bankruptcy protection, one of the protections given by filing for bankruptcy, is that it stays all legal actions going on against you at the moment you file. So if someone's suing you in court, that action is stayed. If your bank is trying to foreclose on your mortgage, that action is stayed. They have to stop what they're doing, and it all gets sorted out within the bankruptcy court under the supervision of the bankruptcy court judge. So like a lot of homeowners did under these circumstances, Aceves filed for bankruptcy and able to protect herself from U.S. Bank's foreclosure on her home. The bank then contacted her and told her that as soon as she was out of bankruptcy, they would work with her to modify her loan in a manner that would allow her to remain in the house. They would restructure her mortgage, make it something that was affordable to her, and she would be allowed to stay. But they told her that as long as she was in bankruptcy, there's nothing they could do about it because they couldn't enter into this modification until she was out of the protection of the bankruptcy judge. So in reliance on these promises made by the bank, Aceves stopped opposing anything that the bank was doing in the bankruptcy court because she believed they were going to live to their promise. As soon as this was all over, they would let her modify her loan and let her stay in court. So sure enough, as soon as it was able to do so, the bank went straight forward with foreclosing on her home, made no attempt whatsoever to try to work out the mortgage with her, didn't even contact her. Right? This was all a ruse to get her not to protect herself in the bankruptcy court. And they foreclosed on her home and they sold it to themselves. So now Aceves files an action to say they can't foreclose on my home. They promised they wouldn't do so. They promised they would work out my mortgage with me and let me stay in my house. And the U.S. Bank said, hey, no enforceable contract. We never entered into a contract saying we do that. We never entered into a contract actually doing it. So therefore, unenforceable. Thank you, miss. We have your house. So the court in this case applied the doctrine of promissory estoppel. They say this is a classic case where promissory estoppel should be applied. Number one, the bank knew when they told Aceves that they would work out her mortgage in a way that would allow her to remain in her house, but she just had to get out of bankruptcy court first, that it would induce her to rely on the promise and not protect herself with the protections offered by bankruptcy court. And she showed she did rely. She stopped protecting herself in the bankruptcy court with respect to her mortgage, relying on that promise. And three, she lost her house as a result of not protecting herself. So the court said definitely an injustice resulting from her reliance. So she was able to prevail in that case and get her house back. Right? Another common place we see these promissory estoppel coming into play. I don't know why this comes up so frequently, but it does. Some employer induces an employee of another company to quit their job, to move across country, and to start working for them. And they promise the employee 2 years employment, 3 years employment. And as we'll see later on when we start talking about what contracts are required to be in writing, one of the types of contract that has to be in writing is a contract that can't be performed within 1 year. It's going to take more than a year to perform it. So these types of employment agreements where I'm going to hire you for 3 years, I'm going to guarantee for 3 years, I can't fire you except for good cause. Those are the types of contract that have to be in writing. So employers will say, we want you to quit the job that you have. We want you to relocate cross country, sell your house, get rid of your business in the state you're in, come drive across country, get set up here and work for us. And we will hire you for 3 years. We're putting the lawyers on it right now, but we need you yesterday. So you'll get your contract. You'll get your contract with the lawyers. You know how long lawyers take, those darn lawyers. Get out here. Yep, you get out there. You start working a month, 2. You're asking about your contract. Still on the lawyer's desk. Still on the lawyer's desk. But, we'll get it to you eventually. And then 3 months, 4 months, they decide, they don't like you so much after all. So they terminate your employment. And when you try to sue to enforce, they promise to hire you for 3 years, they say, hey, that type of contract has to be in writing. Show me your written contract. And again, that's the kind of case where a court is going to apply the doctrine of promissory estoppel. Making a promise that you know is going to induce reliance. The plaintiff does rely, and the plaintiff suffers some big injustice as a result of the reliance. Okay? So those 2 exceptions, even though no legally binding contract is made, where the courts will nevertheless hold a party as if they had entered into a legally enforceable contract. Quasi-contracts and promissory estoppel. So that is the end of Chapter 9, our general overview of the law of contracts, and we'll dig into all of these various elements in a lot more detail as we continue on with the chapters.